Thank you. Others in opposition, please.
Ryan McElhaney with the Community College League of California, and today testifying on behalf of the Association of Community College Administrators as well. We'd just like to echo the ACCJC's concerns and reiterate that the commission is made up of commissioners who were voted upon by California's 112 community college districts, and that these commissioners are the folks that that our districts, our colleges, have decided that they're the ones who can adequately decide on accreditation policy and procedures, and we feel that they should maintain that independence and the ability to do so. So thank you.
Thank you. Others in opposition.
Ashley Satude on behalf of North Orange County Community College District. In opposition, we'd like to align our comments with ones previously stated by ACCJC and the Community College League of California. Thank you.
Thank you. Others opposed to the bill.
Casey Elliott on behalf of Rancho Santiago Community College District in opposition.
Thank you. Okay, members, questions from members?
Would it be okay if we address some of the comments made, or would you prefer just questions first?
I don't want to have a colloquy between the two of you, okay? So maybe if members have questions, we're able to entertain that. Senator Block. And then Senator
Mr. King, could you respond to the comments by
Mr. Block. Senator Block.
I'll be very, very brief. I'm sorry. Just to give you a sense, I know that the commission states that they're for transparency. I'll just give you my own individual experience about how transparent they are. I believe it was last December, when they were looking at closing San Francisco City College, which is obviously a very important decision. I asked to attend the meeting. I was told that I could not attend or be allowed in the room during their deliberation. I was told that if I wanted to speak, that I could only go to public comment. The public comment, just so you all know, was a 15-minute deliberation. It is time limited. In fact, this is in the San Francisco Chronicle. We had a student up there from San Francisco City College. Obviously, I believe it was a he. His life was being impacted. And rather than allow him to finish his comments because the time was up, the chair cut him off. That's how transparent this organization is. In addition, they recently had their meeting in Oakland. And during the public comment period, which is again for public comment, the chair asked the people who went to testify during public comment what their public positions were on my two bills, which is absolutely, completely inappropriate. I don't think any of us who would not be allowed to run public comment this way. So if this is your idea of transparency, if this is your idea of openness, then I think you should vote against these bills. But if you think something is wrong with that, I really urge your support. I think President Claire wanted to briefly talk about the federal regulations very, very quickly.
Hang on for a second, okay?
Yes.
Please. Dr. Pan, you have a question or comment?
Well, thank you. Having served on the accreditation body myself, certainly I understand the importance of ensuring that the accreditation process is transparent, is also credible, and I mean independent. That's another part, and that they're looking at the facts. I am concerned about reports about inconsistencies in the evaluation process, and I guess one question for the ACCJC. So when you do a review, and what are the processes in place for if there are certainly you have a team go in, and in fact we've even heard in the pro testimony that there was a team that the staff had already essentially drawn the conclusion before the team even visited it, right? And that certainly is very concerning to me. And then also, certainly I think people try to strive for consistency, but if there's inconsistency or there's factual errors or misinformation, what are the opportunities for institutions to correct the record, to try communicate in the process to ensure that there's actually accurate information by which the commissioners actually make their decision, that they're not misinformation that or misunderstandings that then cause for an adverse action that may not be based on something that's true or accurate?
Thank you for that question. There are several ways in which there are protections or opportunities for the college to raise issues, both related to conflict of interest and to procedural error. From the beginning, when a proposed team is created to visit a college, the names and the contact information about the team members is sent to the college so that the college can review and give input as to whether there's a conflict of interest. Sometimes they are prior to that, the teams themselves, the team members have been asked to review and attest that they do not have a conflict of interest in accordance with the conflict of interest policy. Once the college reviews and raises issues of, if there is a raise of an issue of conflict, which there occasionally is, those people are removed from the team and additional team members are added to constitute the team. At the point of an actual visit, there is the opportunity for interaction and interview by the team members with all kinds of representatives of the college, as well as with members of the public. There are some required forums in which the public can come in and speak, potentially raising the issue for, if there is an issue that needs further review. Once the team has left, they develop a report, a written report. When it is in draft form, the written report is sent to the college leadership for review of error of fact. That process takes any number of days and back and forth between the team chair and the leader. If there are changes that are needed, the team chair coordinates with the team members to have those changes made in the team report. Then they send a final team report to the commission offices, and the commission offices send them to the college saying, here is your final team report. You have the opportunity to provide a written comment to the commission and to come in person to the commission to address any issues with that report. And numerous colleges actually take advantage of that. In terms of the training,
just to clarify,
yes.
so that final team report is then made available to the institution.
Yes.
So that they could comment or respond to that before it goes to the commission.
Yes, and there have been instances where the team report then has been changed by the commission based upon the input from the college. And so that does happen. Just to say in terms of training, our trainings are done by staff members. I have not heard a person make a comment about a college needing a particular or being likely to have a sanction. That would be not a practice that we would be engaged in, because as staff members, we're not a part of the decision-making process. So there's not a way for us to even decide anything like that. But when there is an adverse action, that would be saying you're no longer considered one of our accredited institutions, perhaps with some issues to work on, even serious ones, but there's a decision made that you are going to be removed from accreditation, then there is more opportunity to file a review request for a commission review of its own action, an appeal at administrative level, and some other steps before that would become effective.
And perhaps, can you comment, the proponents have noted there have been several reports, state auditor report here in California, there was a Superior Court case, and even the U.S. Department of Education knows some deficiencies in the processes and determinations. And I think, can you comment on how those happen and how things are to be addressed, and perhaps also I can have the proponents comment on that as well.
All right. I believe that the auditors report on accreditation was requested by legislators through a committee process. Besides the auditor's own recommendations, which were kind of to try and align the ACCJC with being more like a public agency, it is a private nonprofit organization, but to make it more like that, they did a survey of the member institutions on several questions, and the respondents, by a large majority, more than high 80 percentiles, responded that they felt that the teams were appropriate, the recommendations were appropriate, and that the outcomes for their accreditation experience was appropriate. I would say that would be understandable that institutions would not agree or want to be placed on sanction, and so that would be normal. But the feedback was quite heartening about the sense that really the accreditation process works and is effective. One thing on the lawsuit I would just say, obviously the lawsuit was related to a particular case, and so I don't want to get into that so much, but in looking at all of the efforts of the ACCJC that went into the evaluation of this college, the judge determined that there was no need to have a redo of the evaluation, that by and large the evaluation was fully fair, there was no unfairness, and it was without conflict. There was one procedural element that required a remedy that is being pursued. Actually, it's in the closing stages to remedy that issue. But in all other ways, there was no need for a remedy, and that the activities of ACCJC are in fact fair and in accordance with the policy. I'm not sure if that answers your question.
Okay, I didn't know if Member Ting wanted to address that.
I was going to let
the response.
Just because I think
yes.
President Clare has some more intimacy with some of these issues, I was just going to allow him the opportunity, if that would be okay.
Assemblymember Ting, please go through the chair.
Oh, yeah.
Okay, you're not running the meeting, all right? Thank you.
Apologize.
If it would be okay to allow
Please. All right.
to allow President Clare to address some of these issues, would appreciate it.
Thank you. And I think the one thing that I would want, I know I don't want this to be a big debate between the ACCJC and myself. I think, there's some policies in place, certainly, and they all make sense, but I want to talk to you about the reality on the ground when you do these visits. So one of the provisions of the bill that I'm particularly in favor of is really this opportunity to have meaningful dialogue between the member institution and the visiting team. Because while Dr. Johns is correct that there is an opportunity for you to comment on a draft of a report, I can tell you, in the case of my institution, I received that report Wednesday at 4:30, or I'm sorry, Wednesday at 4:30, the day before the Thanksgiving holiday, and I was asked to provide comments back to the net. I don't blame the ACCJC on that, but I was asked to provide comments back to the team chair no later than the following Monday at 4:30. My staff was gone, so we had to scramble, and it was difficult to respond because I did not have staff on hand to do that. Most importantly, the dialogue is limited to errors of fact, which means that you can comment on things like if the address of your college is wrong or the level of attendance is wrong, but you cannot have a dialogue about the interpretation of standards. And again, in our particular case, we are actually held accountable to a standard that did not exist. We pointed it out in our errors of fact report, even though technically we weren't supposed to. I had a conversation with a member of the ACCJC staff. I wrote a letter to the president of the ACCJC. I stood before the commission and had my opportunity to speak with the commission. It was all ignored. 1 year later, when we did our follow-up report in a conversation with that same staff member, they actually admitted, oh, you're right, we did hold you accountable to a standard that does not exist. Again, it's human error. I don't fault anybody, but the lack of opportunity to have a meaningful dialogue around what are significant outcomes for these institutions is missing. It's a procedural element that's missing that I believe this bill would help in a long way in improving. I'll close in just a second. I'm a certified public accountant. I was an auditor at one time, and I kind of look at the audit process as being analogous to the accreditation process. And frankly, as an auditor, you're expected and have an opportunity to sit down with that entity you're auditing to talk about the issues. Here, it's a one-way communication, and I think it's not a practice that's very effective. Thank you.
Thank you. Senator Hancock.
Thank you, Madam Chair. I'm in the position of having actually not had time to read the state auditor's report. Maybe everybody else on this committee has, I don't know. And I also am not familiar with the nuances of the federal laws. I did work for the U.S. Department of Education at one time, but not in the community college division, but there are federal laws that regulate these things. And I'm not sure to what extent we would be running into problems there. I would like to see that clarified. My situation is this. I want to thank the Assembly member for bringing not only these bills forward, but for raising the issue. I might very well be in support of measures to increase transparency and accountability in the accrediting organization if I knew we were going to not run into federal law problems. And I knew that all of the things in the bill, there are 6 or 8 or more clauses, each and every one of them was in fact responding to a real problem. Some of them may be. Bureaucracies can be insensitive and they can be arbitrary. And one of our roles is to not let that happen. But also, to me, it's unfortunate that this is kind of wrapped up in a very contentious and controversial ruling of the Accrediting Commission in relation to San Francisco City College that is still going on. And honestly, if we interject ourselves, I'm concerned that our community college's accrediting system loses credibility because it could be seen as the accredited policing the creditors and everybody having a chilling effect on an honest and tough evaluation. Personally, I would like to see this be a 2-year bill, come up in January, and have a serious hearing on all of these issues, because I think there are some real issues here that we have to deal with. My question right now is, are there written procedures that the accreditation board has and follows that we could review? Is there written federal law and regulation that the committee ought to review too? And that would be to both the author and the others.
Yes, to both of those questions. There is policy concerning conflict of interests, when and how review of draft reports is done, conducting of public sessions, making the commission actions public. All of those things would be available in policy.
Is there a policy called the policy that we do, and it will go down these items?
Yes.
So those of us who are interested can actually go and look at the different clauses and see if they're adequate.
Yes, ma'am. It would be a little longer than that. It's about 130 pages, but we could flag the pieces on these particular subjects.
Because I think that having a transparent and clear process is extremely important.
Yes.
And if it's lost in a document, I've been through some things where people were disqualified for grants, not by you, but by other education agencies, because they missed that on page 34 of the grant application, a voluntary call was made a mandatory call.
Right.
Now,
Yes.
I don't think, there seems to me there ought to be something short and concise that says this is the process that we use, this is what you're entitled to. And
Yes, ma'am, they are by topic. So a topic, you know, you can look up that topic, it would be short and concise. And to your second question, yes, there are federal regulations that can be looked at as well, including guidelines for how accreditors are evaluated. So there would be some of that information. And the evaluation does include the implementation of policies and procedures, and looks at examples of those. That's part of the federal process.
okay.
I was just going to say that it's not our intention with this bill to not conform or comply with federal guidelines, so we'd be happy to take any amendments or any particular, you know, additions to make sure that we do that. We don't believe that we are in, you know, not conforming to federal guidelines, but again, we're happy to make that much more explicit in the legislation.
Yeah, to me, it would be better to actually go over the federal guidelines and do something in a more serious and focused way, because you can put in a clause like that if this is in conflict with federal law, we won't do it. But it would really be good to know.
We've done, I believe, the best job that we can in terms of doing that. Having said that, I think the measures that we've put in here are sort of common sense, good government measures that are really applied up and down the state.
And would this apply to other states as well, just California?
Just California. So not, they govern California, Hawaii, and the Pacific Islands, so it would not cover any of their other territories.
Senator Mendoza, and then Senator Block.
Thank you. I have a few questions. I just want to ask from the ACC, JC, if there's anything here in this bill that you like, that you say, like, you know, this is actually pretty good.
You know, I've really appreciated the attention about accreditation and quality education that has been on the forefront for the last couple of years here in California. I think we haven't had, you know, people interested in receiving notification of our actions like, you know, recently in terms of please make sure certain legislative committees are included. We've sent them through to the BPPE and to the state chancellor, but not to legislators. I've appreciated that. I think that's very healthy. And I think we're in a phase now where more people are wanting to know about a rather arcane process, a process that's been around for 50 years in our nation that has usually been, you know, the speak or the vocabulary of a certain group of people in higher education. I think that that's excellent. I also think that the measures of the bill reflect good practice. They reflect actually the practices of the ACC, JC now, by and large. That is not our concern. It's really about the implementation into statute and the implications of that for our compliance with federal law and the ability to have a region that applies across, outside the borders of California, and to do that fairly.
We, in California, we always pass legislation that other states don't abide or don't like, or, you know, they get used to or they eventually adopt. You know, but we're leading the way in many ways. But, you know, these three, what I've read in this bill and with the procedure that Senator Ting has brought forward, I mean, if you worked in local government, you served in local government or any capacity, we live by many of these here, and it works fine. It actually, I personally like it. It's unfortunate that it doesn't apply to many other places, but I think that's the attempt that the Senate member is bringing forward. I want to ask another question, and maybe, I don't know if the Senate member yourself can answer both. If a college receives a sanction from the ACCJ, or their accrediting commission, that they believe that it might be an error, What is the appeal process? How do they appeal it? Maybe both of you can
right.
answer that. Does I remember?
May I clarify on this? I think is an issue in the bill. Right now, the actual term appeal is reserved for when there is an action that would result in loss of accreditation. If there, for actions that are short of that, and that's a very rare and unusual action. In terms of California public community colleges, that action has only happened twice in the 50-plus year of ACCJC. But all the actions short of that have various stages during the accreditation process that allow a college to raise issues. And with all due respect, President Claire, when you raise an issue related to a factual error, that will impact whether or not something is or is not deficient in terms of practice that would lead to noncompliance. For example, if the report says a certain process is not in place, and you say, yes, it is in place, that would make the difference on whether something is in compliance with standards. So along the way, there's the opportunity to influence the outcome by raising important concerns. And that opportunity is the opportunity of the college. It has not been the opportunity of third-party individuals, to this point in time.
Well, what we see is in two other regional accrediting bodies, both in New England, the New England Association of Schools and Colleges and the Northwest Commission on Colleges and University, they do allow member institutions to appeal any particular process. So if you're put on probation or if you're put on warning, you are allowed to appeal those. We think that's a good practice. Right now, currently, there is no formal recourse. So in case you disagree with that, you would actually have to go to court, which I don't think is really the most productive way to go.
If I just may, there are accrediting commissions that allow appeal from probation, but that's because they define probation as their most severe sanction. What we really need to have, and the processes we've built in, are ones that continue us on a momentum towards progress, meeting standards, and so forth, rather than in an oppositional process that says you're trying to take our accreditation away and we need to have a dispute about that.
Well, that
is reserved really toward the end.
Yeah, it's going to go through a legal recourse. Isn't that extreme?
This isn't legal. We're not talking about legal recourse. We have the recourse of requesting a review of the commission's action and of an appeal that is done by an appellate hearing panel. Those would be prior to litigation. So there isn't the need to pursue litigation in the case of an adverse action unless the various 2 or 3 administrative remedies are not completed to the satisfaction of the college.
I think the appeal should be as internal as possible before you get to that point, personally. But okay, that concludes my question.
Thank you. Senator Block.
Yeah, thank you, Madam Chair. Like Senator Hancock, I've expressed concerns to the author and others who visited my office about us getting involved in this process that should be really between the colleges and the accrediting commission. But I do see the situation before us as being exceptional, almost analogous to the Heald College issues we dealt with earlier, where there are people suffering, students suffering, and I think it calls for exceptional state action. So while and the author knows I have concerns about this bill, but it seems that, not having firsthand knowledge, it seems that a lot of decisions by this accrediting agency have been personality-driven as much as factual-driven, and that concerns me greatly. I think Mr. Ting's bill will go a long way in making sure that personalities don't enter into what should be fact-based decisions. So with that, having expressed concern, I'm going to move the bill.
Okay, Senator Pan.
I just also want to say that in agreement with Senator Block that I think the fundamentals. There are probably some things that were brought up that I hope that you will work with the opposition in terms of some timelines and so forth. But I think the basic thrust of the bill and the fundamental policies that are in here, I certainly am support, and I think we need to keep this conversation moving forward. I think there's some minor details that I think probably would be good to try to address, but I appreciate you taking this forward. Thank you.
Thank you.
Okay, so I'm going to add just a little spin to this. The community college has a task force on accreditation. They have finished their meetings as of May 2015, and the report is due this fall. I've asked Mr. Tang to include or be able to include those recommendations in his bill. He has rejected that because he wanted to present his bill and take a vote. So I've asked, suggested that all of you hold the bill over and have a hearing on or a meeting in this January when we have some time, so that some of us can read the reports from the auditor and perhaps the federal regs, et cetera, and that we can make a more thoughtful, yes, thank you, a thoughtful discussion about the progress on ACCJC. And I'm also interested, are you folks also being evaluated by the feds at the present time?
We are, and that also will be concluded this fall.
So, for me, the bill is a little forward, and what happens to, we move this bill forward and continue working on it, and then have to, depending upon everybody's coming together and various recommendations, et cetera, how do we put all those ideas together? So, I would suggest that you hold the bill, but you can have a vote also. So it's really up to the committee members. The bill has been moved.
So Madam Chair, I absolutely appreciate all the work that you and I have put into this, and very much appreciate your efforts. I think we can continue to move forward and work together. As you mentioned, that the Chancellor and his task force have said that they were issuing a report sometime in the fall. In previous conversations, he had commented that he was issuing the report in the summer. In previous iterations of the task force in 2012 and 2013, they met and they didn't issue a report or their findings. So while I firmly am confident that they will eventually get their job done, I also feel that the measures that we've really put forward are very modest and simple and common sense here that really should apply regardless of who our accrediting body is. These are all measures that we live by, and I think they can be folded into whatever recommendation. I don't think that they'll necessarily be in conflict with whatever recommendation the Chancellor puts forward.
Okay, so Assemblymember Ting would like a vote. Okay, so let's call the roll. A due pass to appropriations, right?
Due pass to appropriations. Liu?
No.
Liu, no. Runner?
Aye.
Runner, aye. Block? Block, aye. Hancock? Hancock, no. Leyva? Aye. Leyva, aye. Mendoza? Aye. Mendoza, aye. Monning? Pan? Aye. Pan, aye. Vidak? Aye. Vidak, aye. That's
6-2, the bill is out.
Did you want to wait?
Okay, and, I'm sorry. The bill will hold the roll open for Senator Monning.